All right, the court is calling 2018 CR 43496, State of Texas versus Alicio Perez Rodriguez. Can I have parties announced for the record for the state?
Brian Groomer for the state of Texas.
For the defense?
Tony Jimenez, Ron.
And are you Mr. Perez Rodriguez?
Yes.
All right, so I don't speak Spanish, but I know there's a word for Spanish that is not yes. So either we're going to use the interpreter or we're not. So
right away, this hearing feels unusually tense. The judge is trying to establish something basic, communication, but the defendant's responses are already creating confusion in the courtroom. And when language barriers mix with competency concerns, that can completely change the tone of a criminal proceeding. Watch carefully, because this hearing only gets more complicated from here.
So you need to make sure that you are speaking in Spanish.
Oh, yes.
Okay.
Judge, if I may address the court on that. My client was...
Well, before you address it, let me swear in the interpreter. All right, could you raise your right hand? Do you solemnly swear or affirm the testimony, do you solemnly swear or affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do.
All right, and then you can lower your hand if you'll state your name for the record.
Maria Rivas.
All right, and defense, I do have the information from Judge Carruthers.
Yes, Judge, I understand that. I just wanted to make sure that the court understood also that my client, in my conversations with him this morning, he's had 5 medications this morning. He appears to be coherent. He can speak to me. But again, I have a concern. I didn't want the court to misinterpret him at all during this period of entry of the judgment and sentencing in the case. It's just a situation involving his competency. He has been determined to be competent. You have that report. It's just that he has a problem with comprehension. That's why he was not entered into the mental health court. So we've got that balance going on in the situation, Judge. That's all I want.
Oh, no, I understand. But I always want people to know that if we're having an interpreter, we have to use the interpreter, because it gets a little confusing for everybody when we have the interpreter interpreting and they're interpreting English. All right. So the other issue before we get into the case is I see on the docketing sheet that there are immigration issues with him. So we're going to take that up as well when we go forward with the plea. Defense, do you speak Spanish?
Yes, Judge.
All right. And do you speak it fluently?
Yes, Judge.
And have you been able to communicate with your client in Spanish?
Yes, Your Honor.
Mr. Rodriguez, all of the documents that I'm going to review with you are in English. Were those documents explained to you in Spanish?
Yes.
Counsel, have you received all the discovery in this case, and did you review it with your client?
I have. Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Rodriguez, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it and did you sign it?
Yes.
Did you review the document entitled True Bill of Indictment with your attorney and did you understand it?
Yes.
I am a bit confused. I don't know how it's called.
So it is the document that lets you know what you're charged with.
Oh, from immigration.
No, the document I'm referring to, it's called True Bill of Indictment, but that document will let you know what you're charged with. In this case, it's aggravated assault with a deadly weapon. It will let you know the date the state is saying it occurred.
Oh, yes, I remember.
Okay. Did you understand that?
Yes, the paper, yes.
All right. Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Judge.
Mr. Rodriguez, did you review a document entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions? It's the document that tells you what you're charged with. It contains certain rights you have and the plea bargain agreement.
All right.
Yes, but did you review it with your attorney?
Yes.
Did you understand it?
Yes.
All right, did you understand you're charged with aggravated assault with a deadly weapon? That is a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Mr. Leal, you can have a seat.
I'm asking,
You can have a seat.
it must be, I don't know. How do you act when you negotiate your charges?
Well, let's do this first. So I'm going to take it one at a time. Mr. Rodriguez, do you understand what you're charged with?
Yes, yes.
All right, what
Yes, I
you're charged with, the range of punishment is 2 to 20 years in prison.
Oh, yes, yes, I understand that.
All right. If you have a plea bargain agreement with the state, I don't have to follow that agreement. If I don't follow that agreement, you can withdraw your plea. The fact that you entered a plea will not be used against you.
Oh,
Do you understand?
okay. Yes,
You have a right to jury trial, a right for you or your attorney to cross-examine or confront or question any witnesses the state would call, and the right to remain silent. Do you understand?
oh, yes. Mhm. Yes,
Do you understand by entering into this plea bargain agreement, you were giving up those rights?
yes.
Whoa, did you catch that? The defendant just said no when asked if he wanted to give up his trial rights, and you can immediately feel the courtroom pause. This is one of those critical legal moments judges take very seriously. A plea deal only works if the defendant clearly understands what they're agreeing to. And right now, even the defense attorney seems unsure whether his client fully comprehends the question. What would you do if you were the judge here?
And do you want to give up those rights and enter into this plea bargain agreement?
No, no.
Do you want a jury trial?
Yes.
All right. Mr. Jimenez, does your client wish to have a jury trial? I mean, I don't know. Does he understand the question? I'll re-ask the question. So, Mr. Rodriguez, I want you to listen very carefully. Mr. Rodriguez, you've entered into a plea bargain agreement with the state. Do you understand?
Yes,
Do you want that plea bargain agreement?
yes,
All right. Do you understand that if I follow your plea bargain agreement, and if you do not complete everything, that I could sentence you to prison?
I understand. I understand.
All right. And that could be up to 20 years. Do you understand?
Yes,
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
At this point, yes, Judge.
Do you believe he's currently competent and was legally sane at the time of the event?
I do, Judge.
All right. And my understanding, counsel, is that he has been evaluated. Is that correct?
He has.
And the results were that he was competent?
They were.
Mr. Rodriguez, has anyone threatened you or coerced you to get you to enter this plea?
No, well, yes, I've had many things.
No, I want you to listen to my question. I'm trying to find out if you are entering this plea of your own free will. So has anyone forced, no one's forced you to enter this plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
No.
Counsel, we were here last time in August, and I believe an immigration attorney was requested.
That's correct, Judge.
All right. And has the immigration attorney provided him with a letter?
He has, Judge. We sat down this morning. We went through that. He understood and he remembered the conversation with Mr. Otero. He understands the consequences of this plea, and he had no questions about it. He's consented to the entry of the letter, of the Padilla letter to the court.
Okay. And this will be defense exhibit number 1. Any objection?
No objection from the state judge.
All right, then defense exhibit number 1 is admitted for purposes of this hearing. Mr. Rodriguez, were you advised or did someone speak to you about the consequences of entering a plea in this cause and the impact it will have on your immigration status?
How come?
All right. So you're not a U.S. citizen, correct?
Yes.
All right. Did you speak to an immigration attorney?
Yes.
Do you understand what will happen when you enter into a plea to this case? With immigration?
Yes.
All right. Do you understand that there are possible consequences of deportation, denial of naturalization?
Oh, no.
You don't understand?
I understand that I have a felony and that the punishment is from 2 to 20 years. 2 to 20 years. If I'm not a citizen, if I am a citizen, I don't get deported. And if I'm a resident, I'll get deported. I already understood everything the court was saying.
Okay. So, Mr. Rodriguez, if you could do me a tremendous favor, if you will answer my questions. All right. So you're entering a plea in this case. Do you understand that you could be deported?
Oh, yes.
Do you understand that the right to be naturalized could be denied?
Oh, no.
This is where the immigration issue becomes the emotional center of the hearing. The defendant isn't really answering the legal question directly. Instead, he's talking about his family, work, and fear of what happens next. And honestly, this happens more often than people realize in court. For many non-citizens, the immigration consequences can feel even scarier than the criminal sentence itself.
I didn't come. Is that I am quite busy. I don't know. I would like to be given the opportunity to get out of this situation so that my parents and I can work.
All right, so Mr. Rodriguez, I want you to listen to the question that I'm asking of you. Please just answer the question that I'm asking. If there is something else that you wish to say, then you can discuss it with your attorney or you can say it. So my question is, did you understand that you could be excluded from the United States?
No. No.
I don't know, you want to speak to your client?
Yes, Judge, I think clear it up for the court, I believe. The conclusion of the Mr. Otero was that if my client attempted to leave the United States, he possibly would be subject to deportation. But at this moment, he is not deportable. So that's his status. I explained that to my client. Mr. Otero explained it to him, and that's what he understood. And I think that's why it's causing hesitancy because of the language that's being used to interpret.
All right, so it's an aggravated assault with a deadly weapon. He needs to understand that regardless of whether or not this is a deferred adjudication or not, that he could potentially be deported. Laws change all the time. So I just need to know if he understands that he could possibly be deported, that he could possibly be excluded from the United States.
Yes.
And do you understand that?
Yes, I do understand.
All right, the court will find that the defendant has knowingly and voluntarily waived his right to jury trial. According to the plea bargaining agreement, there's an affirmative finding of deadly weapon. The state recommends deferred adjudication. There's to be no contact with Gabriel Ochoa and the DDRF evaluation. Did you understand that to be the plea bargaining agreement defense?
I do.
State?
Yes, Judge.
Mr. Rodriguez, is that the plea?
Yes.
All right, you signed the waiver of appeal. Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Sure.
Defense, have there been any such motions?
None, Your Honor.
Outside the plea bargain agreement, the state is requesting that your deferred adjudication be for a term of 2 years and there be a TAP evaluation. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? What I'm saying is the state wants your term of probation to be for 2 years. That is something the court decides, not the state or the defense. Do you understand?
Oh, yes, I understand.
Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Judge. State would offer State's Exhibit number 1.
We have no objections, Judge.
Mr. Rodriguez, did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? It's the document that contains the police reports.
Yes.
All right. Did you understand that today the state will be presenting their evidence in the form of the police reports and witnesses' statements, and there will be no one here to testify? Did you understand? All right, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states,
Gonna get out of jail.
Mr. Rodriguez. Mr. Rodriguez, you need to pay attention to the questions that I'm asking you. Do you understand?
Mhm.
All right. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding you guilty of you as you've applied for deferred adjudication. Are you proceeding with sentencing?
We are.
Anything you wish to say on behalf of your client?
Judge, I think you have all of the relevant information. You have his history. You have the reports on his commitments. We're just asking the court, in light of all that, that he get supervision by MIOP or some specialized unit in the DA's office, because our concern is his ability to comprehend fully. That's all.
All right. Does he have a place to live or no?
Yes, Judge. His mother is willing and able and ready to take him in at this point and monitor his medications, whatever it is he needs to do.
All right, this is what the court is going to do. The court is going to sentence you to 2 years deferred adjudication. There's an affirmative finding of deadly weapon. There's to be no contact with Gabriel Ochoa. There's to be a DDRF evaluation and TAP evaluation that will happen while in custody. My understanding is quicker while he's in custody. There's to be regular reporting in person or by Zoom. Hostility course, regular UAs. And if he's not eligible for DDRF, can we make sure that he's set up with Center for Healthcare Services and he has a case manager? We're going to do field visits 2 times per month. Mr. Rodriguez, are you employed?
No, I don't want.
Okay. All right. There's going to be proof of employment within 60 days of release.
Oh, yes.
There's to be no employment as a home health care provider or with minors. And there's to be no unsupervised contact with minors. And if his relative wishes for him to live there, then the court will need to have a letter stating that.
Yes, Judge.
All right. Is there anything else with regards to sentencing?
Nothing from defense, Your Honor.
No, Judge.
All right, Mr. Rodriguez, did you review a document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it? It's the document that tells you whether or not you can have what's known as a do-over. Did you read that with your attorney?
Yes.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Mm-hmm.
What does me?
No contest.
No, my question is, do you understand that because I followed your plea bargain agreement and you waive your right to appeal, you do not have the court's permission to appeal? That's either yes or no.
And there it is, after nearly 23 minutes of confusion, clarification, interruptions, and repeated explanations, the hearing finally comes to an end. The judge approved the plea agreement, but you can still sense how fragile this entire process felt from beginning to end. One misunderstanding at the wrong moment could have completely changed the outcome of this case.
Yes.
All right, thank you.
Thank you, Judge.
You're welcome. Excuse me, do you need this? You just have one more.
Yes.
Thank you.
I'll just get your signature right away.
And there's a